Okay, here's the question. Is you get married with your first wife, you list the beneficiaries as your first wife or husband. I'm just using husband-wife situation, right? Then you get remarried, and then you update your will, but you don't change the beneficiary on your RSPs, who's still your first wife or husband. You update your will saying, I now want my new wife or husband to be the, receivership, receive all the, anything if I pass away. Who would win in that argument? Because I've seen this, people have come up where they don't change the beneficiaries on their investments, but their will says the new husband or wife is the beneficiary, but that conflicts what's on the documents.
Okay, so it depends on how they do it.
Do you see this happen often, or?
Sometimes, yes, because what can happen is you are allowed to directly designate the beneficiary on an insurance policy, a registered investment. So oftentimes you will have, when you sign these things up, and they ask you, by the way, do you want to put a beneficiary down here? And it's generally good estate planning to put the name of the person on the direct beneficiary designation so that it doesn't come into your estate. Because anything that comes into your estate will then attract what we used to call probate fees based on the value of your estate. So it's good estate planning not to have your life insurance flow through your estate, not to have your life insurance flow through the will, not to have your RSPs and your registered investments flow through the will and the estate, because they'll attract probate fees. It's better to have direct beneficiary designations made. But then you have a situation where you have an RSP, an RESP, a couple of life insurance policies, and you designate your husband, for example. Your will says, leave everything I have to my spouse, alternate beneficiaries to my kids. That's all nice, you're all on the same page. Now you separate, you change your will. Your new will says, leave everything to my new spouse and my new kids, but your will is silent, as most wills are, as to the direct beneficiary designations on the life insurance and the registered investments, because you don't want them to come under the umbrella of the will and the estate to avoid the probate fees. So far you're good. The problem is when you die, you now have a bifurcated situation where new spouse is going to take what's left over under the will. That doesn't include the life insurance. That doesn't include the registered investments, which, depending on who you are, how well healed you are, can form a significant portion of the actual after-death value of what you leave behind. So you need to think about, do you want to change the beneficiary through the will, which you can do? You can say in your will, I hereby change the beneficiary designations under life insurance policy 1, 2, 3, 4, 5, RSP number 6, 7, 8, 9, 10. But remember then that it brings it inside the umbrella of the estate, and now you're going to pay probate fees. So you always need to think, every time you partner or repartner, every time you separate, every time you divorce, you need to restructure all of that stuff, because otherwise you're leaving pitfalls behind that you may not know about.